I have the opinion of the court in case 23477, United States versus Skrmetti. This case is about a Tennessee law that prohibits certain sex transition treatments for minors. For some transgender individuals, the incongruence between their gender identity and biological sex can cause gender dysphoria, a medical condition characterized by persistent, clinically significant distress. Gender dysphoria in transgender adults and minors is sometimes treated through sex transition treatments, including the use of hormones to induce physical characteristics of the opposite sex. Alternatively, some transgender minors take puberty blockers that delay the development of physical sex characteristics. In 2023, Tennessee joined a growing number of states restricting sex transition treatments for minors. The law, called SB 1, prohibits healthcare providers in Tennessee from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of treating gender dysphoria or related conditions. At the same time, SB 1 permits a healthcare provider to administer puberty blockers or hormones to treat other medical conditions such as congenital defects or early puberty. 3 transgender minors, their parents, and a doctor challenged SB 1 under the Equal Protection Clause of the 14th Amendment. That provision prohibits a state from denying any person within its jurisdiction the equal protection of the laws. But of course, most legislation classifies for one purpose or another, resulting in disadvantage for certain individuals or groups. We reconcile the principle of equal protection with the reality of legislative classification through the application of a standard known as rational basis review. If a law neither burdens a fundamental right nor targets a suspect class, we will uphold the legislative classification so long as it bears a rational relation to some legitimate end. Certain legislative classifications, however, prompt more demanding review. Sex-based classifications are one such example. While our precedent does not make sex a prohibited classification, we have explained that sex generally provides no sensible ground for differential treatment, and that sex-based lines too often reflect stereotypes or overbroad generalizations about the differences between men and women. And so we subject laws containing sex-based classifications to more demanding review. Today, we hold that SB 1 does not classify on any basis that warrant heightened scrutiny and is thus subject to rational basis review. On its face, SB 1 incorporates 2 and only 2 classifications, one based on age, allowing certain medical treatments for adults but not minors, and another based on medical use, permitting puberty blockers and hormones for minors to treat certain conditions but not to treat gender dysphoria. Under our precedent, classifications based on age or medical use do not trigger heightened review. The plaintiffs argue that SB 1 warrants heightened scrutiny because it relies on sex-based classifications, but neither age nor medical use turns on sex, nor does the application of SB 1 turn on sex. The law does not prohibit certain medical treatments for minors of one sex while allowing those same treatments for minors of the opposite sex. Under SB 1, no minor may be administered puberty blockers or hormones to treat gender dysphoria. Minors of any sex may be administered puberty blockers or hormones for other purposes. We also hold that SB 1 does not classify on the basis of transgender status. The plaintiffs argue that classifications based on transgender status should, like classifications on the basis of sex, be subject to heightened review. We need not decide that issue in this case because SB 1 does not exclude any individual from medical treatments on the basis of transgender status. SB 1 removes one set of diagnoses, gender dysphoria and related conditions, from the range of treatable conditions. Absent a showing that SB 1's prohibitions are mere pretexts designed to effect invidious discrimination against transgender individuals, SB 1 does not classify on the basis of transgender status. Finally, we hold that SB 1 satisfies rational basis review. Under that standard, we will uphold a statutory classification so long as there is any reasonably conceivable state of facts that could provide a rational basis for the classification. There is plainly such a rational basis here. Tennessee determined that administering puberty blockers or hormones to minors to treat gender dysphoria carries risks including irreversible sterility, increased risk of disease and illness, and adverse psychological consequences. The legislature found that minors lack the maturity to fully understand these consequences, that many individuals have expressed regret for undergoing such treatments as minors, and that the full effects of such treatments may not yet be known. At the same time, the state noted evidence that discordance between sex and gender can be resolved through less invasive approaches. SB 1's age and diagnosis-based classifications are rationally related to these findings and the state's objective of protecting minors' health and welfare. We thus decline the plaintiff's invitation to second-guess the lines that SB 1 draws. In the past few years, several national health services have revised their assessment of the use of puberty blockers and hormones to treat transgender minors. In 2020, Finland's Council for Choices in Healthcare found that, quote, gender reassignment of minors is an experimental practice and the reliability of the existing studies is highly uncertain. That same year, England's National Institute for Health and Care Excellence published reports finding that the evidence for using puberty blockers to treat transgender adolescents is of, quote, very low certainty, and that the long-term risks associated with using hormones to treat adolescents with gender dysphoria are largely unknown. In 2022, Sweden's National Board of Health and Welfare found that the evidence on treatment efficacy and safety is still insufficient and inconclusive, and that the risks of puberty blockers and hormones currently outweigh the possible benefits. And in 2023, the Norwegian Healthcare Investigation Board concluded that the research-based knowledge for hormonal sex transition treatments for minors is insufficient, while the long-term effects are little known. We do not rely on these determinations, but believe they provide valuable context in assessing Tennessee's law and the similar laws in effect in over 20 states. The Equal Protection Clause does not resolve ongoing scientific and policy debates regarding sex transition treatments for minors. Our role is not to judge the wisdom, fairness, or logic of SB 1, but only to ensure that the law does not violate equal protection guarantees. Having concluded that it does not, we leave questions regarding SB 1's policy to the people, their elected representatives, and the democratic process. The judgment of the United States Court of Appeals for the Sixth Circuit is affirmed. Justice Thomas has filed a concurring opinion. Justice Barrett has filed a concurring opinion in which Justice Thomas has joined. Justice Alito has filed an opinion concurring in part and concurring in the judgment. Justice Sotomayor has filed a dissenting opinion in which Justice Jackson has joined in full, and Justice Kagan has joined as to parts 1 and 4. Justice Kagan has filed a dissenting opinion.